Okay, so I'm getting ready for a hearing, and it's a Social Security disability case. It's an administrative law judge hearing. I'm thinking about what are the things that I do to prepare for a hearing. So obviously, logistically, I got my computer ready. This is a video hearing. They can be video over the phone, or there are times where they're in person. Although since COVID, a lot of it has switched over to video or phone. Most of the time, it's video or phone. That's what we do. Um, but under certain circumstances, and if a claimant requests, they will do it in person. But anyway, that's not what this video is about. This video is about what do I do as a lawyer to help prepare for an administrative law judge hearing. So there's basically three main things. There's a lot that we do, but three things right before the hearing. I would say within a week of the hearing, about a week before the hearing. So one is prepare a brief for the judge. And that's a pre-hearing memo, we call it. It's like a letter brief, usually around 3 pages-ish. Could be 2, could be 4, could be 5. But what the point of the pre-hearing brief or pre-hearing memo to the administrative law judge is to help prepare them for the hearing. So outlining what the conditions are, the diagnoses. The second thing is outlining like what evidence supports the symptoms and limitations that the claimant, my client, is alleging, and giving a theory of disability. So why under the rules and regulations? So I don't think a lot of people realize, could be wrong, but the definition of disability is really, really complicated because it involves a bunch of rulings, a bunch of codes, specific regulations from Social Security, that there's just a lot of rules. There's a lot of different angles, so everything matters, right? The symptoms matter that are outlined in the medical records. The medical records, obviously, everything that's in there, the x-rays, MRIs, opinions of doctors, what we call third-party statements, which is like family and friends and different people that might support your claim. A bunch of things come into play. The main thing is what's in the medical records. And then at the hearing, the judge will hear testimony from the client, the claimant. And so that leads me into the second thing that I do to prepare for a hearing, and that's prepare the client for the hearing. So the first thing is like helping to prepare the judge for the hearing. The second thing is preparing the client for the hearing. So as the client, I provide them, one, with the pre-hearing brief that I gave the judge so that they know exactly what I'm arguing and what the basis of their disability claim is, according to my perspective as a lawyer. And then what I'm doing to prepare the client is I give them example questions. That's not something I've always done in the past. I've always done preparation. So I've been doing this for 16, 17 years in various forms. And I would always prepare them. It usually takes at least around an hour to prepare them. So what I started doing more recently is giving them questions, literally example questions, so that they can review them a week before. So then when we get on the phone to do our attorney-client hearing preparation, they already kind of have an idea of what to expect as far as the questions are concerned, the theory of the case, meaning the brief the judge has. So then that focus time, the day before the hearing, when we actually do a hearing preparation call, that's, kind of filling in the blanks and focused on reducing anxiety. So that brings me to the third thing we do to prepare right before a hearing. And that is an attorney-client preparation call. So we typically do that. I like to do it the day before the hearing. So, and the reason for that is, one, so it stays fresh on the client's mind, what we talked about, and because it's designed to help reduce anxiety. When every single client, 100% of the time, has anxiety before a hearing. It's very, very normal. And so when you're so anxious, a lot of times you can't verbalize what it is that you're going through because you're blocked mentally. This is like cognitive. It's science. It's not just me saying it. It's not. So when somebody is anxious, and they're like, I don't know if it's fight or flight or whatever it is, when they're really anxious before a hearing, a lot of times, like, they'll be very emotional. They'll just have a hard time communicating. So in that situation, part of my job is to calm their anxiety. And so what does that involve? It involves me telling them exactly what to expect during the hearing. So during the hearing, they're going to be expecting the judge is going to sign on. They're going to say X, Y, and Z. They're going to swear you in. They're going to ask about exhibits. They're going to then ask, when was the last time that you worked? What kind of work did you do? Details about the kind of work that you used to do. They're going to go into the example questions that I sent, right? If it's a lumbar case, they're going to ask you, how long can you sit? How long can you stand? Actually, most cases, they're going to ask those questions if there's physical impairments involved. A lot of the questions are directly related to what we call exertional demands of work. So how much can you lift? How much can you carry? And then so we talk about like, how can you express yourself? How can you explain what it is that you're going through to the administrative law judge in a way that your anxiety isn't going to impede it? Because sometimes you can't think straight when you're so anxious or you're so nervous. So sometimes people just say off the wall things. So it's like, all right, calm down. Think about your daily life. Think about the things that you do on a regular basis. How much do those things weigh? I always find like examples are helpful. Only you know what you do during the day. Only you know what you can lift and carry because you're the one doing it. We don't have cameras in your house. So those sorts of things are helpful. So that's the context. And then we talk about experts that might be at the hearing. Virtually every hearing has a vocational expert. So we talk about what their role is, what they're going to say, and, not verbatim what they're going to say, but what their role is and the kinds of things that they're going to say so that, when it comes to vocational experts in particular, sometimes if the client isn't prepped and doesn't realize that they may identify jobs, it sounds like what this expert is saying is like, oh, you can be a cashier, or you can be a phone operator, whatever. So then what will happen is if the client isn't prepared, they will freak out sometimes and be like, I can't do that job. I can't be a cashier. I can't, pick things up repeatedly, et cetera. So they'll be upset. And it's not a good look. It's not a good look for the lawyer because then it shows that, you didn't prepare your client on this aspect of the hearing. And it's not a good look on the claimant because it's like, you just created drama, that's, we're not here for that, you don't have an understanding of what this person is. This person, the judge may not go with that testimony. The judge may not say, oh yeah, you can be a cashier just because that vocational expert gave it as part of their hearing testimony. So it's just not, it's not good. So these are the things. So when I talk to a client before a hearing, we're giving them kind of like, this is what to expect. Because as a human, like I want to know what to expect before I go into something, especially something so big that's like life altering. So those are the main three things that I do to prepare for a hearing in front of an administrative law judge for a Social Security hearing. Hope that helps. Thanks.